Thank you, Cathaoirleach, and thank you, Minister, for being in the Seanad this evening. I'd like to formally move the Employment Equality Amendment Non-Disclosure Agreements Bill 2021 and thank my colleagues in the Civil Engagement Group for their support and sponsorship for this important legislation and for allowing it to be taken during our group's private members' time. I'd also like to thank Sebastian McAteer in my office for drafting the bill and everyone that has been involved in getting it to this stage, including the National Women's Council and amazing activists on the international stage, such as Dr. Julie McFarlane, Zelda Perkins, Georgina Calvert-Lee, Ifoma Ozama, that have so generously fed into the process to date by sharing their personal experiences and insights. I would also like to thank Toby Lawal and Yara Algala for their ongoing research on this issue for my office. I'd also like to thank Minister O'Gorman and his officials in his office for their engagement with me in recent weeks on the bill's provisions and for other colleagues in the House for indicating their support and for attending the bill's virtual launch on Thursday last, in particular our Cathaoirleach Mark Daly and other stakeholders. My personal motivation, Minister, for looking into this legislation over the last few years has been for a number of reasons. One of those was supporting a number of friends who unfortunately signed NDAs before we really understood, I suppose, how far-reaching they were in the community sector. And I think what stood out to me at the time, more than anything at that time, was the community sector, state money, would have paid for those legal fees. And I remember looking into it a bit more and realising how widespread the use of non-disclosure agreements were. I was contacted a few years back in my office from a university, from a group of academics who decided to contact me confidentially about a use of a non-disclosure agreement in their university for the same repeat offender, where they moved him around the college and then eventually on to another school. It is said that these are used throughout technology, through the tech industry, across all different sectors, different legal firms. It's so widespread, but yet so hidden, because people are actually terrified to speak out against them. We were also then contacted by a number of legal professionals who, when they seen our research go out, who were very concerned about the fact that they are, I suppose, obliged to use them as part of their work and they didn't want to use them, and how far-reaching some of those were. In many cases, the kind of stuff that came back on our research was the idea or the misconception that these are in the best interest of the victim. And that's how it's framed to a person at probably their most vulnerable point, after it could be weeks, months, years of bullying, of sexual harassment, of gender-based harassment. And at that point, when they've been offered the NDA, they want out. That they can't stay where they are, and they'll sign anything just to actually walk away and try and build their lives back up again. But that changes. Like everything, it takes more than just time to heal from abuse, sexual harassment or discrimination, but it also takes your voice in the end, and most people want to speak up. And most of the stuff that has come back in our research is that women, after a few months or maybe a bit of distance from the situation, in most cases they have regretted that they're now in this legal bind where they can't actually speak about what they went through. In many cases, some of the concerns that came back to us in our research was the reputation, that colleges or firms or the tech industry don't want to damage their reputation by allowing somebody to speak out. And I think it's very sad that anyone would want to build a reputation on silencing victims. We should want to build our reputation on empowering victims, protecting victims, not the perpetrator. So that would be, there's so many different areas I could talk to in relation to this. The idea, one of the things that stood out to me very much so was the idea of two third parties and who's not at the bargaining table. So the idea, if you're working with somebody and they in any way, discriminate against you or bully you, and that they're protected then, and you give them a glowing reference so that you can move them on. It's known in the industry as pass the trash. So you wipe your hands and you go, do you know what, thank God we're after getting rid of them. But they're gone on to some other unsuspecting university or place of work or place of employment. And some of this stuff is, there's a lot of pattern to their behaviour. So basically when we're sitting down and we're signing an NDA between an employer and an employee, or a perpetrator and a victim, we're not only signing it in terms of the people that are in that room, we have to think of the third parties that we're also putting in danger by giving a glowing reference for somebody to start over again and over again and over again, and their pattern of abuse never be picked up because of NDAs. So what is a non-disclosure agreement? It is a legal agreement that ensures silence and allows for such principles to be protected and a legal basis to protect perpetrators enforced. It is simply untrue and a further manipulation of a victim to apply that settlements require NDAs. NDAs are required to protect the employer's reputation and perpetrator's identity. If they were in the best interest of the victim, then it is only the victim that they would protect. And be under no illusion, this is not the case. In fact, victims, when they have stepped back from the harmful situation and away from the scene of their harassment or discrimination, victims begin to feel stronger in themselves and want to speak out. No one denies that there are many scenarios where a legal non-disclosure agreement may be needed or even desirable. Trade secrets may need to be protected. Industrial relations in progress may need to be safeguarded. Intellectual property may need certain legal protections and guarantees. However, in recent years in Ireland and in other jurisdictions around the world, we have seen a certain creep emerge, where NDAs are now cropping up in scenarios where they were firstly never envisaged, and where secondly the legal silence that they both cause and affect are actively damaging the public interest and common good. Openness, transparency and accountability are fundamental principles of a functioning and fair society. They underpin our democratic systems and the code of conduct by which we all engage with each other in public life. The right to share the details of one's own experience is a fundamental right, a human right, one tied up in the fundamental principles of freedom of expression. And any legal instrument that restricts individuals, groups or communities from exercising said rights must be treated with extreme caution due to the risk that such agreements and the silence that they cause would eventually lead to. When such abuse happens in the workplace, a victim may decide that remaining in a workplace with an abuser is simply too painful if a perpetrator is not terminated, as is often the case. That the victim would then be faced with a legal non-disclosure agreement and forced into unwanted legal and enforced silence about their own painful experiences, utterly and totally indefensible. This practice must be banned, and that is why I am proposing this legislation, to allow victims the time and the space to recover from their experiences without a shroud of legal silence preventing them from sharing their trauma. In terms of the legislation itself, it is a relatively short bill. It would insert a new section 14B into the Employment Act 1997 as amended to stipulate that the use of non-disclosure agreements that relate to sexual harassment and discrimination in the workplace would be extremely restricted and regulated. Essentially, all such agreements would be banned, other than those that are requested by the victim themselves to protect their own confidentiality, i.e. the so-called victim's exception. However, the bill sets out a number of very robust conditions that must be needed for such an NDA requested by the victim to be enforceable. Firstly, the victim must have been offered independent legal advice provided at the expense of the employer. Secondly, there must have been no undue attempts to influence the victim to include a confidentiality clause. Thirdly, the agreement shall not adversely affect the health or safety of a third party not involved in the making of an NDA or the public interest more generally. Fourthly, the agreement must include an opportunity for the victim to waive confidentiality in the future if they choose. Finally, the agreement must be of a set and limited duration. In terms of the bill's other provisions, we would make it illegal for an employer to enter into an NDA with just the perpetrator in order to cover up their unacceptable behaviour. Furthermore, we would make any subsequent NDAs that were signed but were not made in accordance with this bill null and void, and indeed it would be an offence to enter into such a contract. Furthermore, in terms of retrospectivity for NDAs signed before the enactment of this bill, they would be only enforceable going forward if they had also been made in accordance with the strict provisions set out earlier. Furthermore, later in the bill, subsection 8 sets out important provisions relating to the information sharing that even an NDA that is legally signed under this bill cannot apply to. For example, whistleblowing under the Protected Disclosures legislation, communications relating to the harassment with the guards or a lawyer or a therapist. Finally, the bill would require that agreements made under this Act must be written in plain English insofar as possible, that the Minister would make regulations for a standard form for such agreements, and that the Minister would also issue guidelines on the use of NDAs in employment equality practices for employers, employees and also the legal profession. Finally, the last provision would ensure that non-disparagement agreements, i.e. agreements that prevent you from being critical of your employer, would not become a backdoor to further NDA abuse in this area by ensuring that any non-disparagement agreement that restricts a victim from sharing details relating to harassment or discrimination would be caught by the restrictions put in place by this bill. Those are the provisions of the bill. I believe that they are fair and generous in how they support the autonomy and voice of victims of harassment to make themselves heard. I believe it would be one of the most comprehensive regulations of this area in any jurisdiction in the world, and would allow Ireland to become a real leader as we continue to shine a light on the treatment of marginalised at the hands of the powerful, both in our modern-day society as we look back to reckon with a shameful history of institutional abuse and incarceration, particularly of women, minorities and the marginalised. Thank you.